Alrighty. Chapter 7, The Legality of Dirt. The human race runs a dirty ship, and most of the dirt today is produced by machines and processes unknown a century or two ago. In those days, it is true, men's persons, homes, and habits were filthier than they are now. The cabins where people lived on the good ship Earth were a mess, but the rest of the ship was clean. The inhabitants just did not know how to foul up the earth as science has enabled them to do. And for a long time, the technologists and engineers did not realize what they were doing. Everyone took it for granted that rivers and lakes would carry off any amount of waste we dumped into them, that wind would blow away whatever noxious gases and dust we released into the air, that the soil would absorb and somehow purify all the litter we scattered all over it. Eventually, scientists with a few assists from concerned laymen began to learn about the unwanted and undesired products of scientific progress, and law is now being called upon to help the technicians clean up. As long as the only objection to dirt was on aesthetic grounds, the objectors made little progress, although England adopted a smoke abatement law as early as 1273, and a violator in 1307 is said to have been executed. But coal increasingly replaced wood and charcoal. Until nearly 500 years later, Shelley wrote, "Hell is a city much like London, a populous and smoky city." Protests then, and for a long time afterward, were confirmed largely to poets and other finicky types. Only a few years ago, fears that the affluent society was poisoning itself with its own wastes were dismissed as the vaporings of crackpots and alarmists. Now they have become a major issue in politics. At all levels of government, agencies are being set up to protect the environment from science, or with the help of science. The legal basis of such protection seems at first glance to be solid. Any industrial process, any public or private waste disposal, any individual machine that emits harmful or unsightly substances is a nuisance, and a large respectable body of law deals with the elimination of nuisances. Furthermore, anyone, individual, corporation, or government agency who damages another person's property has wronged him, and a whole branch of law covers wrongful acts, known in the profession as torts. This was designed over the centuries to provide redress because, as one of the oldest and most frequently quoted rules of equity states, no wrong is without remedy. Finally, as we pointed out in Chapter 1, and as the rector and trustees of Trinity Church learned in 1895, the police power gives governments very large opportunities for regulating the use of property. So why is it so hard to stop a paper mill from pouring its refuse into a river, or a mine from covering a pleasant landscape with acres of slag, or almost everyone from using internal combustion engines that poison air? I almost said ruin air, but the reason is that for all our statutes and common law on the subject, a great deal of dirt remains legal. One great source of this legitimate dirt is the vast accumulation from many small polluters. Each adds so little to the whole that none can be prosecuted seriously, or so most legislators and law enforcement people seem to believe. Until recently, that is. For example, more than 3/5 of all the contaminants in the air in the United States came from motor vehicles, according to the Public Health Service report in 1967. The total from this one source was a fuck ton. Okay, someone say this out loud for me. 8500000, right? So what the fuck? Dude, I'm sorry. I should know. I used to know. I don't anymore. I don't know how to say it. I only know how to compare it and do the math for it, but I don't know how to say it. I'm sorry. Math is not my first language. I'm sorry. Yeah, but I made it through calculus too, with B+. That's not bad. Or B. I'll just say stick it at a B. Maybe it was a B-, but still, I think it's fine. Anyway, blah, blah, blah. All manufacturing, power plants, incinerators, and other refuse burning, the heating of buildings, and other polluters put so many tons into the atmosphere. Law now requires new automobiles to meet stricter standards than were even known a few years ago, but the increased use of cars and trucks keeps the total of air pollution at about the same level. And every ton of it is legal dirt. So is most of the refuse, gaseous, liquid, and solid that pours forth from homes and factory shops, offices, farms, and camps. In fact, anywhere people happen to be. Nuisance law, which often seems the most obvious deterrent to such practices, has developed in response to public demand, but law and people do not use the word in quite the same way. Law takes the first dictionary meaning, harm or injury. Law takes the first dictionary meaning, which is harm or injury. Popular speech refers to the secondary definitions, which is an annoying, unpleasant, or obnoxious thing or practice, a pest. So according to law, nuisance means harm. According to people, nuisance means pest. Furthermore, law recognizes two types of nuisance, public and private. And so many ramifications that William Prosser, when Dean of University of California Law School, warned that there is perhaps no more impenetrable jungle in the entire law than which surrounds the word nuisance. Generally speaking, a private nuisance is a thing or practice that does damage to the person or property of an individual. Only he can sue to stop it. A public nuisance harms the community as a whole, not necessarily everyone in it, but a substantial number. Are the police a public nuisance? That's a good question. I don't know. I think they are, but they can be improved, and we just gotta crack down on them. Get to cracking, people. Shit, I don't even fucking care. This is Spandrel. There was a bit of a side note, but if the police start fucking policing themselves, maybe, like, actually persecuting the people who are fucking up, maybe the people wouldn't be so fucking mad at the police all the time. Anyway, I'm gonna let that go. We're not talking about that right now. We'll get there. Generally speaking, a private nuisance... Okay. A public nuisance may be a crime. A private nuisance is only a civil offense. Most serious widespread pollution is by its nature a public nuisance, and law has been slower to act against it than private nuisances. Many states have spelled out in statutes specific nuisances, but some of their courts have held that giving a bad name is not enough, and it has to be a nuisance in fact. And the legislature's label is not a fact. So every nuisance suit has to be tried out for size, so to speak. And if the facts warrant, the court permits states to add a nuisance to the rolls in the exercise of their police powers. Smoke, for instance, was not a common law nuisance, but in 1911, Iowa by statute gave smoke abatement powers to cities of more than 65,000 people. Des Moines took advantage of this to prohibit dense smoke in certain portions of the city as a public nuisance. A lot of users of coal complained that the standards set were so strict that virtually all the furnaces in the affected districts would have to be remodeled. Their cries of anguish eventually reached the Supreme Court under the heading of Northwestern Laundry versus City of Des Moines. The laundry company called the delegation of authority to mere commissioners unconstitutional because it deprived furnace owners of the due process of law, which the 14th Amendment forbids. The due process clause is admittedly and no doubt purposefully vague. The lawyers for Northwestern Laundry said that surely it meant more than a rule promulgated by a board. They also contended that the Iowa statute permitted discrimination between coal users in different parts of the city and was both unreasonable and tyrannical. On January 10th, 1916, the Supreme Court unanimously rejected the argument, saying, "So far as the federal Constitution is concerned, we have no doubt the state may itself or through authorized municipalities declare the emission of smoke in cities or populated neighborhoods a nuisance. Nor is there any valid federal constitutional objection in the fact that the regulation may require the discontinuance of the use of property or subject the occupant to large expense in complying with the terms of the ordinance. No man can complain that he is injured by being prevented from doing to the hurt of another what he has no right to do." A California court had expressed this in 1911, granting a permanent injunction against the cement company whose works impaired the value of adjacent residential property. This seems clear enough, and Northwestern Laundry has been cited in suits to prevent pollution ever since, but courts have not always followed the doctrine literally. 15 years after the Supreme Court had spoken, a New York judge held in Bove versus Donner-Hanna Coke Corporation that the air pollution from 50 coke ovens was only a petty annoyance. Who knows what a coke oven is? I do not. Bove, a homeowner near the defendant's Buffalo plant, simply had to put up with it. The court called the smoke from these ovens indispensable to progress. Of course, this was a lawsuit brought under the private nuisance theory, but the same company, taken into court in 1955 on a charge that the smoke from this plant, contaminating the same neighborhood, was a public nuisance, again escaped. This time the ruling was that the smoke was an unavoidable necessity, because the coking ovens were equipped with every safeguard known to the industry. According to this court, coke is sufficiently important to the community that it must be permitted to exceed the pollution standard set by the government. About the same time, a Michigan judge rejected this plea of necessity, saying, "All it costs is money." When Congress considered the point in writing the Air Quality Act of 1967, it leaned toward the New York opinion. In enforcing the standard of purity sought by the statute, the court may consider the technological or physical and economic feasibility in deciding what the public interest and equities of the case may require. Although this was omitted from the original version with the Successor Act of December 1970, giving the Environmental Protection Administrator greater powers to enforce federal water quality standards, a new phrase was inserted during the legislation's peregrination through Congress. This tacked onto the enforcement provisions the words, "taking into account the practicability of compliance." There are loopholes large enough to justify any pollution that a sympathetic judge is willing to allow. Such an escape for perpetrators of a private nuisance is impossible, but then the successful litigant seldom protects anyone but himself. For example, as long ago as 1886, a New Yorker named Cogswell sued to force the New York Haven and Hartford Railroad to move an engine house it had built next to his home. He brought evidence to show that the noise and dust had made his son ill. The state courts agreed with the railroad's lawyer that each member of society must submit to annoyances consequent upon the ordinary and common use of property. But the opinion added this phrase, "provided such is reasonable." Using the land next door to a residence for an engine house is not reasonable. Thus, law managed to distinguish an engine house from the rest of the railroad's operations and equipment. If tracks were laid out only out of earshot of human habitations, people could not be served. Yards must be placed pretty much where traffic dictates. But the railroad can put its engine house where it does not unduly disturb residents who were there first. Even so, essential a service as a railroad must be reasonable. Halfway across the country in 1969, the principle was applied similarly in Bates versus Quality Ready Mix. The defendant made a popular cement and had set up a plant on property it bought well out of town. It adjoined on two sides the land on which the Bates home stood, and the plant itself was 270 feet from the Bates house. The operation was exceptionally noisy and dusty and went on day and night. Trucks came down from the road at all hours to dump large quantities of dry materials that were then hoisted to a tank high in the air and mixed by machinery so incessantly deafening that the foreman bellowed his orders through a bullhorn. The finished product was loaded onto other trucks and carted off with hardly less noise and dust. Even when the Bates family kept all their windows shut, dust and din came through to interfere with their sleep, conversation, and comfort. While no one was actually ill, the company's use of the land was found unreasonable in view of the fact that the Bateses had been there first. To the plea that no one could manufacture ready-mixed concrete without dust and noise, the court replied to this that this simply meant that the plant must be closed, and it was so ordered. The judge made clear that noise alone would have been enough to justify this ruling. He also asserted that a nuisance does not have to affect health, only reasonable enjoyment of property to be eliminated by law. All this was to be to the good. The railroad moved its engine house and Quality Ready Mix its plant to places where no one lived, and the pollution did no obvious immediate harm, which is a desirable way of ending a nuisance. But when the pollution comes down a stream or is blown away by wind, the remedy for the wrong is not so simple. Often the victims have no way of identifying the culprit, or no single polluter or group of polluters may be responsible in the eyes of the law. Scores of factories and a dozen industries may poison a river, but no single plant, perhaps no single industry, contributes as much as the water could handle. The wronged person or group have no one to sue. Recourse in law, therefore, becomes one of the government regulations of the wastes generated. Recent years have seen a rash of statutes at all political levels set to standards for pollution and sometimes even to enforce those standards. Congress has passed half a dozen since 1960. Whether they will be any more effective than the one of 1895, requiring Army engineers' approval of discharges into navigable waters, remains to be seen. The favorite method of regulation has been prohibition of certain objectionable activities, except in areas where they would not offend citizens, or at least citizens who mattered. A long line of court decisions upholds the authority of states, counties, and municipalities to pass and enforce zoning ordinances on the grounds of aesthetics, as well as health or convenience to preserve property values. The first such rules were olfactory. Soap making, tanning, slaughterhouses, and the like, which generated evil smells, were banned from many neighborhoods, even earlier than the original anti-smoke ordinance. However, on premises outside the ban, these factories were permitted to create whatever stench their owners deemed necessary. This was legal dirt. For a long time, law refused to disturb such owners in the enjoyment of their legal rights on their own land that either had been set aside for such pursuits or where the neighbors did not object. But this right was gradually reduced as big cities expanded into outlying areas once set aside for the pariah trades. The Supreme Court opinion, usually cited by lawyers who wish to circumscribe such property rights still further, is one written in 1915 by Justice Joseph McKenna in Hadachek versus Sebastian. The plaintiff was the proprietor of a brickyard. Once it had been located outside Los Angeles, but now it was within the city limits, and a new ordinance made it a misdemeanor to operate such a business in certain districts. The defendant was the chief of police, whose custody Hadachek had been remanded when he refused to stop making bricks. His plea to the Supreme Court was that no one lived anywhere near his yard when he bought the land in 1902. People knew before they moved in how much noise and dirt a brickyard created. His 8 acres were worth $800,000 for making bricks because of the quality of the clay, but only $60,000 as a residential property. Against this, it could be pleaded that the surrounding land was virtually valueless as it had been before the city expanded, unless the brickyard was removed, so the property owner stood to gain more than Hadachek would lose. Finally, he argued the city could not turn a legitimate business into a nuisance merely by calling names. His lawyers knew the Supreme Court had ruled some years before that a livery stable as a legitimate business was not per se a nuisance, but it was within the police power of Little Rock, Arkansas, to declare that in particular circumstances and particular localities, a livery stable shall be deemed a nuisance in fact and law. However, the Hadachek counsel replied, a livery stable could be moved while a brickyard had to remain with the clay. Justice McKenna pointed out that over the years, the neighborhood had become residential for whatever reason, and that fumes, gases, smoke, soot, steam, and dust arising from the petitioner's brickmaking plant have from time to time caused sickness and serious discomfort to those living in the vicinity. Justice McKenna pointed out that over the years the neighborhood had become residential for whatever reason, and that fumes, gases, smoke, soot, steam, and dust arising from the petitioner's brick-making plant have from time to time caused sickness and serious discomfort to those living in the vicinity. Even though Mr. Hadachek had been there first, the only limitation on the police power was that it not be used arbitrarily or with unjust discrimination, which Los Angeles had not done. The justice neatly turned against Mr. Hadachek the argument of many polluters that what they do is part of our advancing civilization. He wrote, "There must be progress, and if in its march private interests are in the way, they must yield to the good of the community." Furthermore, Justice McKenna did not think the case so different from that of a livery stable, for Hadachek could take the clay from his 8 acres and make bricks elsewhere. Hadachek versus Sebastian and the many cases after it served to concentrate the obvious legal dirt where it would be relatively unnoticed or unobjectionable. But a great deal of dirt was not obvious, and in the absence of proof of damage, it remained legal everywhere. New York City incinerators, for example, routinely poured about 50 pounds of dust into the air for every ton of refuse burned. By the time a local ordinance set a limit of 5 pounds a ton, effective in December 1968, the total dust in the New York region from this single source was 15,000 tons a year. In the city, the excess over 5 pounds was legal until the new law went into effect. Most of the millions of tons of pollutants from our automobiles and trucks are legitimate, although new cars are obliged to be a little cleaner than the old ones, at least for the first few thousand miles. New York City is still within the law whenever it empties 1 million gallons of raw sewage into its rivers every day. Law is more effective if it deals with these problems at the source, the car manufacturer or the government of a city, than if it tries to arrest everybody who litters in the streets. Either way, though, law must first end the dirt's legal sanction. Cleaning the good ship Earth is, like peace, an ideal to which almost everyone subscribes. Yet the ideal falls so far short of realization that year by year the world gets dirtier. People cling to their own particular ways of fouling the common nest while deploring the other fellows. Most of us drive our cars more rather than less. The uses of paper increases, although its manufacture is one of the foulest of industrial processes, and the final product adds up to half or more than the solid wastes in any large city. Americans who enjoy a day in the country burn forests, pollute streams, destroy nesting and feeding grounds of the animals they come to see, and they leave a trail of garbage wherever they pass. Science has given them the means to do all this and much worse. Whether science can reclaim what has been done what has already been destroyed is doubtful. There is hope that it may learn how to redress some of the wrongs technology has loosed. If it does, law can help or hinder, whether these problems concerns the land, the water, or the air. Each of these three poses its own particular legal dilemma.